Hello all, today we are discussing a very important and evolving issue in digital governance. Something interesting has happened in the country of Australia. Last year in the month of December, Australia has banned social media for children. This topic becomes extremely important not just from technological angle but also from governance, mental health, constitutional rights and many more. The entire world is presently watching the country of Australia and seeing whether this social media ban of children will actually work. So, with this in background, let us first understand why this issue has suddenly come into news. In December 2024, Australia passed a law called as Online Safety Amendment Act 2024, Social Media Restriction. It clearly mandates that the children below 16 years cannot hold social media accounts. However, the government allowed 1 year transition period, giving companies time to prepare technically and legally. Most importantly, the law does not punish children or parents. Instead, the responsibility is shifted entirely to the technology companies. Now that we understand the basic structure, let us see which platforms are actually covered under this ban. The platforms covered. The ban applies to platforms whose primary purpose is social interactions. This includes Instagram, Facebook, TikTok, Snapchat, Reddit, and X. Interestingly, YouTube was also included, even though it has educational content. Regulators argued that YouTube's recommendation algorithm can expose children to harmful and addictive content. At the same time, Australia realized that a blanket ban could disrupt essential communications, so some platforms were kept outside the law. Messaging platforms like WhatsApp and Facebook were kept out of it. Online gaming platforms like Roblox were also excluded. Educational tools like Google Classroom and YouTube Kids remain accessible. The intention was to ensure that children are not cut off from education, communication, and child-friendly digital spaces. Once the platforms were identified, the next question was, how will companies be forced to comply this? So if the platforms fail to take reasonable steps to prevent under 16 users, then they can be fined up to 49.5 million Australian dollars, roughly 270 crores. The phrase reasonable step is important because it gives regulators flexibility. Again, the law avoids criminalizing families and instead targets corporate accountability. This reflects a shift from user-focused regulation to platform-focused governance. But why did Australia feel the need to take such a strong step in the first place? Let's see. The reasons behind the Australia's ban. The primary concern was teenage mental health. Australia observed that there was rising cases of anxiety, depression and self-harm among adolescents. A government study revealed that nearly two-thirds of the children aged 10 to 15 had been exposed to harmful online content. The debate was also influenced by Jonathan Haidt's book, The Anxious Generation, which links social media to declining mental health well-being. However, even well-intentioned laws often generate debate, and this one was no exception. Public response was largely positive, with about 77% of Australians supporting the ban. Parents in particular welcomed the move as government backing. However, many academic and UNICEF criticized the law. They argue that banning access does not address deeper problems like addictive algorithms, attention economy design, and platform incentives. And beyond public debate, they also raise serious technological and privacy related concerns. Now let us understand what are the methods used for verification of age. To enforce the ban, platforms adopted tools such as facial age estimation, ID verification, and third-party checks. These methods rely heavily on biometric data and personal identification. While they may improve compliance, they also raise concerns about mass data collection and surveillance. This leads us to the next major challenge, whether such enforcement is actually effective in practice. So in reality, the enforcement had not been perfect. Many teenagers have started using VPNs, fake date of births, or they are even borrowing the accounts. This shows that regulation often becomes a technological cat and mouse game. So what has actually happened on ground since the law has been enforced? Meta reported blocking over 5 lakh accounts under 16 within weeks. However, teenagers quickly shifted to alternative apps not covered by the ban. This indicates that while laws can reduce access, they cannot completely eliminate the digital exposure. And apart from practical challenges, the law is also facing serious legal scrutiny. The law has been challenged in Australia's High Court. Petitioners argue that it violates freedom of political communication, which is protected under Australian Constitution. Reddit has also argued that the ban restricts young people's participation in public and political discussions. But with this background, let us now examine what this entire debate means for India. India has adopted a different approach. Under the Digital Personal Data Protection Act 2023, children below 18 can use the social media with verifiable parental consent. India has chosen regulation rather than a total ban. However, detailed rules on how consent will be verified are still pending. And even if a state wants to go further and ban this, constitutional realities must be considered. Now let us bring all these threads together. Australia's under-16 social media ban is a global policy experiment. Its long-term impact on mental health, privacy, freedom of expression is still uncertain. For India, the challenge is to design a balanced policy that protects children while respecting the constitutional rights, privacy, and digital inclusion.